Hello everyone, and thank you for coming to this, the latest in a series of product liability talks given by 2CG's product liability team. Sorry for the slight 2-minute delay, but we were trying to give it a little bit of time for people joining the link late. My name is Tom Fairclough, and together with my colleague David Thomas, we are going to talk about the broad theme of product liability claims and the cladding crisis. I'm going to talk for around 15 minutes on the Defective Premises Act, the DPA, and the cladding crisis, and then David will speak about the thorny issue of cladding claims and pure economic loss. So starting with my first slide, and hopefully you've all received the PowerPoint presentation by now, entitled What is Cladding? It sounds simple, but actually what is cladding? At its most general, it is used in construction or added to pre-existing structures as an exterior panel or as part of some exterior system, usually designed to improve eco-performance or the aesthetic of a building. Cladding is sometimes made up of different components by different manufacturers, each possibly being a different product in its own right, and can, separate but related to cladding, have, for example, insulation behind it, again, as a separate product by a separate manufacturer. Examples of cladding being used in high-profile fires include, for example, the Grenfell Tower fire and the Bolton Cube fire. The growing public consciousness post Grenfell Tower about cladding has led to litigation arising out of the use of cladding and changes in the law, which I want to touch on today in the context of the DPA. So my next slide is entitled DPA 1972 and Duty. The DPA is an important act because it creates a statutory cause of action that avoids or helps to avoid issues with privity of contract between builders and eventual purchasers of flats or houses, and issues with pure economic loss, which David will be speaking on. It is a potentially powerful tool in the claimant's arsenal. So this slide lays out the relevant aspects of establishing a duty under the DPA. A person taking on work in connection with the provision of a dwelling owes the person ordering the work, or every person who acquires an interest in the dwelling, a duty to see that the work is done in a workmanlike or professional manner with proper materials so that the dwelling will be fit for habitation. And what I want to do during this talk is break down some of those features, particularly when cladding is an issue. So the next slide is entitled Dwelling. A dwelling, like many things in the DPA, isn't actually defined, but it effectively means, according to Catlin Estates Limited, any building used or capable of being used as a dwelling house, not being a building which is predominantly used for commercial or industrial purposes. And like many things in the DPA, it's a question of fact and degree for each individual judge, and there are, of course, borderline cases about commercial properties that might have people staying in them occasionally. Importantly, for reasons we'll come to, within an apartment block, for example, each flat is a dwelling and a duty is owed in relation to each flat and those who obtain an interest in any particular flat. It also means that the limitation might run at, or start to run at different points for different flats, all within the same building or complex. The next slide is entitled Provision of a Dwelling. The DPA only applies to work for or in connection with the provision of a dwelling, whether the dwelling is provided by erection or by the conversion or enlargement of a building. So if you build a new house or a new apartment block or a new complex from scratch, then that is straightforward. That is work for or in connection with the provision of a dwelling. Likewise, or at the other end of the scale, if you're a plumber and you come and fix the shower, you do so negligently and the house floods, well, you might be liable in contract or in tort, but you probably aren't within the scope of the DPA 1972. The much harder cases involve refurbishment works to buildings that already exist. And whilst this is a question of fact in each case, in Jensen, which is on the slide, it was said in a summary judgment context that when considering whether some work has been done in relation to the provision of the dwelling, the question is whether, on the facts of the case, the identity of the refurbished or extended house or dwelling is wholly different from the old house or dwelling. And whilst it's a question of fact, it's important to note that in Jensen, it was said the issue is more of a metaphysical issue than an issue which could helpfully be resolved by the assistance of expert evidence. And so it's not a science. The court isn't looking to see, or just to see if you have more space or if it's been an internal refurbishment to spruce up the place, but whether the nature of the dwelling or its identity has fundamentally changed. And in the construction industry, we know that the use of cladding on refurbishment projects varies in scale. It can involve just adding cladding to a building, or it can involve adding cladding to a building in the context of huge multi-million-pound refurbishment projects that keep the skeleton of the existing building but change virtually everything else. And one needs to think carefully about where each individual case falls within that spectrum, and whether or not the work being done is in relation to the provision of the dwelling. Is it changing the nature of an existing building if it's an existing building case? The next slide is entitled Work on a Dwelling. In short, if you install a product, that probably means you've performed work on the dwelling, subject to any defences you might have, which are outside the scope of this talk. Likewise, and for the avoidance of doubt, whilst the language of the DPA is framed in positive terms, i.e. performing the works, active, the DPA applies to failures to do things, so a failure to check compliance of materials, or a failure to install a particular safety feature, as well as actually positively doing things, and that's well established in the case of Andrews and Schooling. More importantly, a failure to remedy defects when coming back to check your works or coming back to carry out remedial works may constitute fresh works, giving rise to a fresh cause of action. And that's the case of Alderson, which is on the slides. Where a developer, in that case, built a flat, the flat had damp issues. Later, after someone had bought the flat, the developer came to try and rectify the problem on several occasions. They failed to rectify the issue, and for limitation purposes, the claimant had to pin her cause of action on the failures to remedy rather than the initial completion of the dwelling, which was more than 6 years before the issue of the claim form. The claimant succeeded in that case, with the Court of Appeal holding that where a developer did further work to rectify a defect, there was fresh cause of action. And in various property, certainly in the cladding context and in the large-scale property developments or property refurbishment context, this may well be relevant because it is common for developers or contractors to come back and work on properties, picking up sort of snagging issues months or even years after practical completion. And one should, as a general rule, think carefully about whether such works could give rise to fresh and discrete courses of action. And the reason this is so important is simple: limitation. And the case of Sport City is key. So in Sport City, cladding was put on a building being constructed, and practical completion was either in 2007 or 2010. Remedial works with the cladding were carried out in April 2014 or in 2017, and a claim was issued, or claims were issued, in May and August 2019 and January 2020, i.e. more than 6 years after 2010, but less than 6 years after April 2014. And the claimants in that case only pleaded defects caused by the original works. They didn't plead in the particulars of the claim any cause of action based on the later works, the remedial works. And the defendant pleaded limitation defence, and the claimants put in a reply saying, well, the later works, the failure to remedy, meant causes of action continued. And unfortunately, whilst the judge accepted in that case that later works could give a new cause of action, the judge said neither the performance of further work nor a failure to perform such work operates to revive an existing but statute-barred cause of action. And as such, it's important to make sure in the DPA context, and particularly in the cladding context where remedial works may have been done or may have purportedly been done, one pleads each separate occasion of work after completion if the same could give rise to a viable cause of action. It might not resuscitate limitation barred claims, but it might help to keep a claim in prospect. The next slide is entitled Fit for Habitation. The claimant has to prove that the dwelling is unfit for habitation, and the question is whether the dwelling as a whole is fit, even if defects are not on the specific dwelling. So in Harrison, it was held that defects in foundations that rendered the dwellings unfit, notwithstanding the fact that the damage to the properties themselves was fairly minor. And one might also think of cladding based on an apartment complex, but not necessarily on your particular apartment. That dwelling still might be unfit for habitation. The test is set out in the Rendlesham Estates case as follows. For a dwelling to be fit for habitation within the meaning of the DPA, it must, on completion, A, be capable of occupation for a reasonable time without the risk to the health and safety of the occupants. And what counts as a reasonable time is a question of fact. Or B, be capable of occupation for a reasonable time without undue inconvenience or discomfort to the occupants. The way one proves unfitness will vary in context. Sometimes it'll be perfectly obvious that a building is totally unfit. For example, real issues that have already occurred with, for example, flooding. Other cases will not be as easy, particularly if what one is arguing is that the building is unfit because of the as yet unrealised risk of something occurring. And this is important in the cladding context, where there are so many different cladding products, systems and configurations that some may be unsafe, some may render it unfit for habitation, and some may not. And hence, in the Naylor case, cladding case, the claimants wanted to amend their particulars to plead that the building was unfit for habitation because there was significant risk of harm from fire to the persons living in the flats. And after considering the relevant expert evidence, the judge said, I do not in any event consider that there is a real prospect that the question of fitness for human habitation will turn on anything other than the question of fire safety, and that will in turn turn on the evidence of the relevant experts. So, and in that case, the judge found the expert evidence didn't come up to proof and didn't come up to what was needed to allow the amendment. The judge couldn't say that the fact that it was cladding on the building rendered it unfit for habitation. So I appreciate that sounds trite, but it is important to make sure expert evidence is in place as and when it's needed, particularly if you're dealing with future risks, because an expert will be needed to comment on the likelihood of those risks and what might occur if the risks eventuate. The mere fact of particular cladding being used probably isn't enough to show that a building is unfit for habitation. The next slide addresses limitation, and for reasons I'll come to in a second, we're in a slight flux when it comes to limitation and the DPA following the passage of the Building Safety Act. Currently, limitation runs from 6 years from when the dwelling is completed, and as discussed, a new course of action with another 6-year period accrues following remedial works. This has caught out a large number of people following increased public consciousness and litigation or threatened litigation relating to cladding because their flats were completed more than 6 years ago. And unlike negligence actions, the latent damage provisions in section 14A of the Limitation Act, so where you don't have knowledge of the damage, don't apply to the DPA because those provisions only apply to actions in negligence, and the DPA is not an action in negligence. So even if you're not aware of the defect, even if you're not aware of the fact that the building, for example, had cladding on it that was dangerous, well, you're time barred on the current law 6 years after the dwelling was completed or your cause of action accrued. I then note on this slide that limitation will soon change following the passage of the Building Safety Act, which gained royal assent a week last Friday, but is not yet in force. My understanding is that the government have said they intend to bring the limitation provisions of that act into force ASAP, but that of course doesn't mean they necessarily will, and the governments, or various governments over the years have often said we intend to bring something into force, and it's remained dormant on the statute books. If it is brought into force, the relevant provisions of the Building Safety Act will, amongst other things, amend the Limitation Act to give a special time period for claims under the DPA. In short, for new causes of action under the DPA, causes of action that accrue after the coming into force of the Building Safety Act, there will be a 15-year limitation period, as opposed to a 6-year limitation period. Perhaps more difficult or more concerning, depending on who you're representing or which industry you work in, for causes of action that have already accrued before the new Act comes into force, the limitation period will retrospectively change to 30 years, i.e. issues potentially as far back as 1992 will be able to be litigated. That raises a whole host of difficulties, not least to do with prejudice, retrospective changes to the time bar, and so on, and how this will affect ongoing litigation where the claim form has been issued, particulars of claim have been pleaded, and the defence has been put in with raising limitation issues. Clearly, these are points that will have to be discussed and thought about on each case, not least, as I say, because these provisions are not yet in force, albeit, as I say, my understanding is the current plan is that the Act will be brought in the next 2 or so months. The final slide is entitled Practical Tips and mainly focuses on limitation. As I say, although the new 2022 Act is great from a claimant perspective, my view is if limitation is approaching, you still want to issue a claim. So if the limitation period is about to come to an end, you still want to issue a claim if you can. Courts have been forgiving in the cladding context of issuing claims and then needing time, perhaps a stay or an extension, to properly plead and investigate your case. And there is a case that's on the slides from a recent case where the claimants issued a claim to stop the limitation from running, but needed a stay to obtain full and proper expert evidence. And the court gave that stay despite the defence saying, well, this is abusive, because when you issue a claim, you should be ready to plead your claim. The court in the cladding context was forgiving. So this is not an area where the courts seem to have struck out claims as abusive for not being able to fully particularize the case at the point of issue. And for what my money's worth, that is a reason to issue if you possibly can and are in a position to do so, regardless of the fact that the 2022 Act will soon come in and extend your limitation period. That's all from me on this topic, and now I'm going to pass over as gracefully as I can to David, who's going to talk to you about pure economic loss. Thank you very much.
Thank you very much, Tom. I would like to talk about the issue of pure economic loss as it may arise in cladding claims, where the cause of action is in common law negligence. In certain circumstances, it may be necessary to bring a claim in common law negligence alone, in the absence of a direct contractual link between the parties, or to take advantage of the potentially more generous limitation periods available for latent damage in negligence, as has just been mentioned by Tom. The fact that, in the absence of a specific assumption of responsibility, economic loss is usually irrecoverable in common law negligence claims is a principle with which many of those watching will be well aware. However, this does not prevent the rule from being a somewhat thorny concept, nor one that may not have tripped up many practitioners from time to time. In the next 15 minutes, I will talk about the nature and scope of this exclusionary rule, how it has been and how it is likely to be approached by the courts in cladding litigation. If I could ask you to turn to my first slide. The nature of the exclusionary rule for pure economic loss in tort is best explained by way of an example. And in the context of construction claims, the best example is the well-known 1990 House of Lords decision in Murphy and Brentwood District Council. The facts of Murphy can be stated quite briefly. In about 1970, a firm of builders built an estate of houses on Vineway in Brentwood, and the house that is pictured on the slide is one of those houses. Pleased to note that they are still standing. Mr. Murphy purchased one of these houses from the builders, but unfortunately for Mr. Murphy, the houses were built on unsuitable raft foundations. These foundations had been approved by Brentwood District Council as the relevant building control body, and it was not controversial that it was negligent of Brentwood to have done so. In the beginning of the 1980s, cracking was observed at Mr. Murphy's property, and its cause, the unsuitable foundations, was ascertained. In 1986, Mr. Murphy sold his house at a significant undervalue, and really his insurers, pursued a claim in respect of that undervalue against Brentwood District Council on the basis that the building control body had been negligent in approving the foundation design. Obviously, there was no direct contractual relationship between Mr. Murphy and Brentwood, and his claim was brought in the tort of negligence alone. Just turning over to the next slide, that claim was dismissed by the House of Lords. And one of the reasons for the dismissal of the claim was that the defects in Mr. Murphy's property, namely the unsuitable foundations, had become apparent before any injury or damage had been caused to persons or to other property, with the house and its foundations being considered a single structure, a single item of property for these purposes. As such, the defect was considered in law to be a purely economic loss, in that it was merely a defect as to the quality and thus the value of the product the house supplied to him. The House of Lords held in Murphy that in the absence of a special relationship of proximity between the parties, such losses are not recoverable in the tort of negligence. It should be noted that the defendant in Murphy was the building control body, in respect of whom there may be particular policy reasons for not imposing a duty of care and tort. However, the House of Lords, and in particular Lord Bridge, who we will be hearing more from later, made clear in the quotation that's on the slide that the exclusionary rule in respect of pure economic loss would equally extend to a claim and tort against a builder. Having set out the principle in general terms, I would now like to look at 3 recent cases which have considered the exclusionary rule in a context relevant to cladding claims. Turning over to the next slide, and the first recent case I'd like to discuss is the decision of His Honour Stephen QC in the Manchester Technology and Construction Court in Sport, City Management and Countryside Properties. This was a strikeout summary judgment application, which you'll remember was mentioned by Tom in the context of Defective Premises Act 1972 limitation. However, this case also provides a general example of the application of the exclusionary rule for pure economic loss in the context of a modern cladding claim. One of the blocks in the Sport City living development can be seen in the photograph on the slide. And you can see an awful lot of wood and plastic-looking cladding on that photograph. Needless to say, there were complaints about the fire safety of the cladding, as well as issues with fire stopping and cavity barriers at the development. The claim was brought by the development's management companies against the developer pursuant to the Defective Premises Act, as well as in common law negligence. Now, as can be seen from the extract on the slide from the judgment of His Honour Judge Stephen QC, the claim in common law negligence was struck out following the principle in Murphy. Now, by analogy with the defective foundations in Mr. Murphy's house, this was because the existence of potentially dangerous cladding and other fire safety defects within the property owned by the claimants, which had not caused personal injury or damage to other property before the defects became apparent, is considered pure economic loss, and thus, as in Murphy, is irrecoverable in tort. If I can ask you to turn to the next slide, which deals with a slightly more specific issue. And the next case is the decision of His Honour Judge Kayser QC in the TCC at Cardiff in Thomas and Taylor Wimpey. Now, Thomas is not a cladding case per se, but its potential relevance to cladding cases will become apparent. The claimants in this case were the owners of properties at the Church Bell Sound development in Bridgend, which they had purchased from Taylor Wimpey in or about 2007. The substantive complaint here was not in respect of the houses themselves, but it was in respect of a defective log timber retaining wall in the back gardens of the properties, which required rectification to ensure its continued stability at a cost of some £200,000. Again, claims were brought under the Defective Premises Act and in common law negligence. In respect of the common law negligence claim, and what makes Thomas relevant for present purposes, is that the claimants relied upon another part of Lord Bridges' speech in Murphy, in which he set out what he considered to be a valid qualification to the general exclusionary rule for pure economic loss. And the relevant words of Lord Bridge can be found on the slide. As can be seen from the first part of the quotation, Lord Bridge would carve out an exception to the exclusionary rule if a building stands so close to the boundary of a building owner's land that after discovery of the dangerous defect, it remains a potential source of injury to persons or property on neighbouring land or on the highway, which I'll discuss as the boundary qualification. Now, the reason for the boundary qualification, according to Lord Bridge, and this exception to the general exclusionary rule, is that upon the discovery of such a defect, the building owner should be entitled to the cost of doing such works as are necessary to protect himself from potential liability to third parties. Now, it would not be much of a stretch of the imagination to apply this principle to cladding claims. If one has large panels of potentially combustible cladding that are liable to, or even designed to, detach from a tall building in the event of a fire, one can see that they may well pose a risk of injury to people nearby, or to property on neighbouring land, or to a nearby road or highway. However, in Thomas, His Honour Judge Kayser considered that Lord Bridge's boundary qualification does not represent good law, more that it was a matter of judicial freelancing. A similar approach was taken in the case of George Fisher and Multi-Design Consultants, a first instance decision from 1998. There, the claimants argued that the risk of a defective roof blowing off and presenting a danger to users of a nearby motorway fell within Lord Bridge's boundary exception. His Honour Justice Hicks QC held that it did not, and he doubted the correctness of Lord Bridge's comments. However, the cases don't all go one way, and His Honour Judge O'Donoghue in Morse and Barrett, another first instance decision, relied on Lord Bridge's comments in Murphy and applied them to allow a negligence claim against Barrett in respect of an estate's retaining wall which was adjacent to a highway where the claimant homeowners had been required by the local authority to fix it, as it had become unstable and thus, in the eyes of the local authority, presented a danger to the public. It should be noted that all the cases expressly considering the boundary principle are at first instance, and given the inconsistency between the decisions, there is surely room for further argument on this point. Again, turning over to the next slide, and the final case I would like to discuss is the decision this year of Mrs. Justice Joanna Smith in a strikeout summary judgment application made by one of the defendants in the Advantage litigation. This case concerns a lack of compartmentation and fire safety measures in a modern timber-framed retirement home, which was almost entirely destroyed in a fire, as can be seen from the photograph on the slide. Advantage, the claimants, were the PFI contractors for the development with an obligation to repair, and WSP, who were seeking strikeout, were the fire engineering design consultants for the development. Now, the decision of Mrs. Justice Joanna Smith considers a number of relevant issues. First of all, and although the question of when there will be held to be an assumption of responsibility for economic loss, which would allow recovery for such losses in tort, is outside the scope of this talk, it should be noted that Mrs. Justice Joanna Smith refused to strike out such a claim against WSP, despite the lack of a direct contractual link between the parties, and despite it seeming as if the parties had arranged their affairs so as to avoid there being such a contractual link, so there could still be a freestanding duty of care and tort. Second, and just turning over to the next slide, in the absence of personal injury or damage to other property, the fact that this was a case where a significant fire did occur and the risks posed by the fire safety defects complained of had actually eventuated does not change the nature of the loss suffered in the hands of the claimant from being pure economic loss. This may feel counterintuitive looking at the scale of the destruction wrought, but it should be remembered that in Murphy, the risk posed by the defective foundations had also eventuated in the form of cracking to Mr. Murphy's house. As such, in Advantage, this is still the same type of loss in the hand of the claimants, just on a clearly more dramatic scale. And as explained in the quotation that I put on the slide, it did not constitute direct physical damage to the property by WSP. Third, and finally, Mrs. Justice Joanna Smith quickly dismissed an argument made on behalf of Advantage that WSP's design constituted negligent instructions, which, according to dicta in an old line of cases concerning builders being given negligent construction instructions, which led to their personal injury, may avoid the exclusionary rule for pure economic loss. As such, it seems that such a principle, referred to in Keating, will be tightly construed. Turning over to my final two slides, I would just like to end with a couple of thoughts as to where litigation and further future cases may go in this area. In particular, the recent cases discussed above have not expressly considered the question of whether cladding or overcladding designed and installed by a specialist sub or subcontractor may be considered as a separate component or structure to a building, such as that damage caused to other elements in that building by the cladding should properly be seen as damage to other property, such that it does not constitute pure economic loss. And in that regard, I've put on this slide two quotations from Mr. Justice Aikenhead, both at summary judgment stage and at trial stage in the Linklaters and McAlpine litigation, where he noted that there was a dearth of English authority on this subject. And therefore, turning over to my final slide, thus, in the right cladding case, again, say the right specialist cladding only subcontractor, there may be space for the re-establishment or resurrection, what is sometimes known as the complex structure theory, as expounded by Lord Bridge, yes, him again, in Murphy, or a similar theory along those lines. The complex structure theory suggests that there may be an exception to the general exclusionary rule where some distinct item incorporated in the structure positively malfunctions so as to inflict damage on the rest of the structure. Now, I can well see the difficulties in such an argument where the cladding or external wall system forms part and parcel of the profile of a new build development, as it would be difficult to say that the implicated cladding product is a distinct item incorporated into another structure, as opposed to being a product integral to the main structure of the development. However, the analysis may be more in a claimant's favour in circumstances of a refurbishment or overhaul of an existing building, which includes an element of overcladding above the existing external wall facade. In such a case, the overcladding may arguably be seen as a distinct item, discrete from the building that stood independently prior to the refurbishment works. One thing is clear, however, given the nature and extent of cladding and associated claims being brought and yet to be pursued, the general exclusionary rule for pure economic loss in this context is likely to be tested further in the near future. Well, thank you very much for listening to Tom and myself this afternoon. And I would just ask you to keep your eyes peeled for the next invitation to this series of 2TG Product Liability webinars. I hope that you have a good afternoon and a good evening. Thank you.